Welcome to our webinar, Legal Update. My name is Miranda Ward, and I'm one of your Client Relations Directors here with Davis-Stirling. We are thrilled to see so many of you today. We have a lot of information to cover, so we're going to get started. Before we begin, this meeting is being recorded. If you require closed captioning, please request it at the bottom of the screen. This video will be available on our YouTube channel after the webinar is processed. The link is going to be posted into the chat right now for easy access to that. We will be taking questions via the Q&A function to be discussed at the end of the program. If we do not get to your question, please check the newsletter. Some questions may be answered as the presentation progresses. Also, two specific of questions will not be addressed. Now on to the presentation. Please welcome Rob Ward, Alison Greiner, Karen St. Onge, and Jamie Handrick.
Hello, everyone. Thank you for joining us today. It is a pleasure to be here giving you this webinar on a legal update for 2024. I'm joined by three excellent attorneys who are all in various parts of California working for us here at Davis-Stirling. Alison Greiner is in the Inland Empire. Jamie Handrick is down in San Diego with me. And Karen St. Onge is up in Northern California. And we're all members of the CLAC community, which is the California Legislative Action Committee. And so we felt it would be a good idea for all of us to get together today and give you our take on the latest legislation that was just passed here in California. We have about 6 bills we're going to talk about. We're also going to give you some case law, 5 different cases that we think are interesting that you should know about. And then right at the end, we're going to talk about sort of an obligation that you guys have. It's the Corporate Transparency Act, and a case that sort of accompanies that. We've given a webinar on that already. I urge you to check it out on YouTube or on our website. It's fantastic. It was run by Natalie Stewart and Lori Poole, our managing partner, one of our managing partners. And so a lot more information can be garnered on the Corporate Transparency Act if you go to our website. So we're going to talk about some of the bills that CLAC supported, 3 of them, in fact, that were supported by CLAC and that were signed. We're very proud of that here in CLAC. That's AB 2114, AB 2460, and AB 2159. And each of us are going to give our spiel on each of these bills. So you'll hear a different speaker for each of these bills today. I'm going to start out with the first one in time, because this was 2114. This is the Inspection of Exterior Elements bill. And what you're seeing on the screen right now, oops, excuse me, there we go. What you're seeing on the screen right now are some examples of exterior elevated elements that are part of what we call the balcony bill. You've heard of the balcony bill. It's been around for several years now. The balcony bill is something that was passed after the tragedy in Berkeley about 6-7 years ago. A balcony collapsed, and legislators got together and decided they were going to do something about that, and they passed SB 326, and that required that, here, let's go to the next slide so I can show you. That required that inspections be done periodically by qualified experts for wood frame structures that have these exterior elevated elements, sort of like balconies or landings that are wood framed. And that this first inspection would have to take place no later than January 1st, 2025. So experts would need to be retained to perform these what we call these random and statistically significant sampling of inspections of these particular areas. And that's to say that enough inspections have to warrant a 95% confidence in the samples. And then they would generate a report, which would be incorporated into the reserve study for the association. And if there were any immediate threats to safety or anything noted by the expert, they have to be reported to the local code enforcement agency within 15 days of completion of the report. And then the board would have to take preventative measures, including maybe restricting access to these balconies or unstable landings that were found on this inspection. And if the association doesn't comply with this, well, it could be subject to some penalties. So The question today with this bill, 2114, is what experts can actually do this. Previously, only a licensed structural engineer or architect could perform this inspection. Well, over the last few years, the associations have really tried to retain these licensed professionals to do these inspections, but they're becoming scarce. There's a limited number of architects and structural engineers out there that are qualified to do this work. And it's gotten more and more busy, more and more difficult to get them booked. And the legislature saw that meeting this deadline, which was December 31st, 2024, would be difficult for many associations who maybe couldn't find an expert who's available to do these inspections. So what they did was they passed this bill, 2114, AB 2114. It's an urgency bill, which means that as soon as it was signed, it went into effect. And it actually did go into effect in July of this year, July 15th, 2024. And what it says is that they're adding civil engineers to the list of professionals that can go ahead and do these inspections. So it's not just structurals anymore. It's not just architects. You can have civil engineers jump in and do this because they needed to find more qualified professionals that could assist with the demand for getting these inspections done. Okay. Now, what's really important about this, first of all, these inspections have to be conducted every 9 years, but the first one is due in January 1st, 2025. And there has been some confusion out there, and I want to make sure that you all understand. This bill is not to be confused with AB 2579. That applies to SB 721 or apartment inspections. That bill actually gave them some extra time to complete these inspections, another year in fact. And a lot of questions are coming in right now about whether we have that extra time as well. CIDs do not have that extra time. That bill does not apply to CIDs, only this one. And it gives you the civil engineering component that can help out. But unfortunately, we do not have extra time, and that deadline is rapidly approaching. So obviously the takeaway here is if you haven't had these inspections done and you're required to do so, if these exterior elevated elements are in your common areas and require this inspection be done by January 1st, 2025, please get on that now. It's important to find someone. We can certainly help you with that. There are resources out there available to you, and hopefully you're not behind the 8 ball on this particular requirement. So that's really all I had to say about that bill. What we're going to do now is move over to the electronic secret ballot bill, AB 2159. And that is going to be done by Alison Greiner. So welcome,
Yes.
Alison.
Thank you, Rob. Yes, so my name is Alison Greiner. And as Rob said, I believe we're all on a legislative action committee. I serve on the one for Coachella Valley. So yes, so 2159, the electronic secret ballot bill. This is what I think is everyone's favorite bill. It also might be the longest bill. So there's a lot to this one. There's a lot of requirements that associations will have to be aware of. And I won't be able to do a deep analysis on that here today, but I will touch on the main points of it. So this bill amends certain sections of the Civil Code related to association elections. It authorizes associations to conduct elections using an electronic balloting procedure. So it's important to note that this does not completely eliminate written ballots. It does not apply to elections regarding regular or special assessments. Those must still be conducted the old-fashioned way. And associations will still have to allow members to vote by written ballot if that's what they prefer. And then, although the bill does not require associations to amend their bylaws or CC&Rs to allow elections by electronic ballot, however, associations will have to amend their election rules to allow electronic balloting. So of course, that means that an election can't be held until at least 90 days after those new election rules have been adopted. So it's important to remember that if your association has an annual election in early 2025, you may not be able to use electronic voting this upcoming year, but you should still start getting prepared for it. And also, regarding that, definitely ask your legal counsel about the timing and if you're able to use electronic balloting. So the associations, in order to use electronic balloting, they'll have to decide whether to use an opt-in method or an opt-out method. And the most simple way I can come up with to explain that is if you're going to use the opt-in method, that means that the association's default method is written ballots, and they're giving members the option to opt in to using an electronic ballot. And then if you're using the opt-out method, it's the opposite. The default is the association is using electronic ballots, and the association gives members the option to opt out of using the electronic ballot. And information on the procedures to opt in or opt out will have to be included in the association's annual policy statement. Using electronic balloting will extend the election timeline for elections. Maybe that's bad news, I don't know. But it will extend the election timeline, except for regular and special assessments. Those will still remain the same. But for director elections and for amendments to the governing documents, the election timeline will be extended. And what we are suggesting is that the election process will have to start a minimum of 120 days prior to the election date. So that's what we're suggesting. And that could even be longer, but a minimum of 120 days. So what that looks like is 120 days prior, the association will notify members that electronic ballots are being used and that they have 30 days to change their preferred voting method from electronic to written or from written to electronic. And the reason for the 120 days notice of that is because the statute specifies that 90 days prior to the election date is the last day for members to change their preferred method of voting from electronic to written or written to electronic. So 90 days prior is the last day for them to change it. So back up, and we're suggesting 30 days to give members notice of that deadline. So if using the opt-in method, and this is just sort of an example of what that notice might say, something along the lines of, we're proceeding with an election and we're using written ballots, but you have the option to opt in to using electronic, and if so, you must provide the association with an email address, etc. If you're using the opt-out method, the statute actually specifies that the notice that is sent to the members must be delivered by individual notice 120 days prior. And that notice has to include the member's current voting method. If that method is electronic and the association has an email address, it has to include that email address and an explanation that the member has, that they're required to opt out if they want to use a written ballot, and an explanation of how to opt out. So that's just a brief overview of some of the notice requirements. Nominations from the floor are prohibited when using electronic balloting. However, write-ins are not addressed in the bill, so it's possible that will still be an option. And then an electronic ballot is effective once it has been transmitted, and then it's irrevocable. Something interesting is, or something beneficial, is the text of a governing document amendment. So that could be a restatement or just an amendment. The text of that amendment can be provided via email to the members that have elected to vote by electronic ballot, which will save the association money and save some trees, probably. But if a member requests a written copy, the association still has to provide the written copy at no charge. And then just like I said, there's a lot to this bill, but so the inspectors will have to, update their system, and they'll have to, comply with the new requirements here as well. Some of those requirements are the inspectors will have to ensure that their system can authenticate a member's identity, can transmit the ballot to ensure secrecy and integrity. And they'll have to have a method to confirm 30 days prior to the election date that the member's computer or device can successfully communicate with the inspector's system. And then the inspector will have to transmit a receipt, a voting receipt, after receiving a ballot, permanently separate the member's identity from their ballot, and store and keep ballots accessible to the election officials. So that's a brief summary of the electronic secret ballot bill. And up next, I believe we have Jamie Handrick with 2460.
Thanks, Allison. That was complicated.
Oh, I do want to say though that we are working on this, and we will have election rules ready to go, and contact us if you have any questions. It is confusing, but it's doable.
Yes, remember that all of this is being done so that you have the option of voting electronically, which is a great thing. So everybody should be happy. But there are some steps we've got to take to amend those rules.
Yeah.
It is. I can't tell you how many times I've heard from boards saying, well, we don't want to pay for postage. We don't want to pay for copies. We don't want to mail all that stuff. So now you don't have to anymore. So that is a beautiful thing.
Yes, I think overall it's a very good, good change.
Yeah. All right, we're going to talk about AB 2460 now. This has been referred to as the reduced quorum bill. This bill was passed really to clean up legislation from last year's passing of AB 1428. The bill amends Civil Code Section 5115 and Corporations Code Section 7512. So this bill covers two code sections that you need to look at. One of the important changes to Civil Code Section 5115 is that it identifies what should be included in notices to members for election of directors and recalls. Section B6 says, if the association's governing documents require a quorum for an election of directors, a statement that the association, that's the key word here, the association, may call a reconvened meeting to be held at least 20 days after a scheduled election if the required quorum is not reached, at which time the quorum of the membership to elect directors will be 20%. Voting in person, by proxy, or secret ballot. So 20% of the association's members voting in person, by proxy, or secret ballot. That is a statement that will have to be included. The other thing that came up with the legislation, and there was confusion, and all of this really was poor word choice on the part of the author of the bill. I mean, that's what really created all these problems. There's confusion with existing law about who can call the reconvened meeting, because one of the parts of the statute currently says it's the board of directors that can call the reconvened meeting. And then another part of the statute says it's the association that can call the reconvened meeting. So what they did this year is they cleaned up the legislation to say the language says the association, meaning the homeowners, right, can call the reconvened meeting. So now in the bill it says association. It no longer says board of directors. So that's important for everybody to know. The new bill also talks about the process of adjourning a meeting when quorum is not achieved. The language was changed to make it clear that if quorum is not achieved, the meeting will be quote unquote adjourned to a quote reconvened meeting where the reduced quorum of 20% is required. So again, it's really just semantics and word choice, but it makes things clearer this time around. Remember also that the reduced quorum does not apply if your governing documents provide that the quorum is lower than 20% of the members. So if you have documents that say your quorum is less than 20%, this does not apply. The association also, if you plan to use electronic voting, the new law requires language to be added to the notice regarding voting by electronic secret ballot. So everything that Allison just talked about with electronic voting, you are going to need to put information about electronic voting in the notice as well. That's in this bill. Just make sure you check with Association Council to revise your membership notices to include the language that's required in this new law. That's my takeaway for you. Check with your attorney, make sure you're changing your forms and your notices so that everything is included that needs to be in there. Okay, that's it for me. Karen's going to talk to you now about SB 477.
Hello, yes, so my name is Karen St. Onge. I'm up here in the Bay Area, and I volunteer with the Bay Area Central Valley chapter of CAI, and I'm the liaison for the chapter with CLAC. So I'm going to talk about a couple bills. The first one is SB 477. So it addresses ADUs, or accessory dwelling units. So if your HOA has architectural guidelines or rules regulating the construction and use of ADUs, they probably prefer to section of the California government code. Well, those code section numbers changed this year. So basically what happened as ADU laws were added to the government code, they were scattered throughout different areas, making the ADU laws not very user-friendly as far as where to find them if you want to actually look them up and read them. So this year, the legislature consolidated all of those code sections into their very own chapter, hopefully making it easier to access and understand. So how does this affect you all in the HOA community? If your association has ADU rules and guidelines that reference the government code, those section numbers are obsolete and you may want to update them. It's not a requirement, but I'm sure it would help everybody if you had the accurate codes. All right, so that's all I have to say about that one. We're going to move on to SB 428. All right, so SB 428 actually was passed last year. So this is from last year's legislation. However, part of it that pertains to workplace restraining orders, TROs, temporary restraining orders, goes into effect January 2025. So that's why we wanted to talk about it today. So what it does is it takes an employer's current right to seek a TRO to protect their employees from violence and threats of violence and expands that to include harassment. And the reason that we are talking about it in this webinar is because homeowner associations are considered employers, even if they don't technically, have an employee that they're paying money, but volunteers, including your volunteer directors on the board, volunteers on committees, independent contractors who do work for the association, they are all going to be protected, and the HOA can go to court and get a TRO to protect those individuals from now, starting in January, from harassment. So what is harassment? So the statute defines it. It's a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, or harasses the person and serves no legitimate purpose. In addition, the harassment has to cause a reasonable person, so again, that kind of a fictional reasonable person, to suffer substantial emotional distress. So this is not just the everyday kind of annoyances. And there has to be clear and convincing evidence that it actually did cause substantial emotional distress. So if when the employer goes to court, they're going to show that they're going to prove by clear and convincing evidence that the harassment was suffered, that great or repairable harm would result to an employee without the order, and that the speech or the conduct has no legitimate purpose, and that speech or activity is not constitutionally protected, otherwise known as, your freedom of speech. So that's going to be one really important area to distinguish is making sure that you are not stepping on someone's constitutionally protected right of free speech. All right, so another change is adding that the victim, regardless of whether it's for harassment or violence or threatened violence, the victim has an option to opt out of being named in the order. So if the victim does not want to be named in the order, the employer can still get a TRO to protect all their other employees from this individual. So I think that's an important change. Now, just a little background on this bill. The author who introduced this bill actually cited that the reason that they needed to expand employers' right to include harassment as grounds for a TRO was because of the uptick that they saw and that had been being reported out there during COVID. That ever since COVID and during that lockdown, there has just been an uptick of incivility, and in the HOA community, I know we have seen it also. Members of boards and managers, there's just being the victims of bad behavior. So hopefully, just with the threat of a TRO, this will curb some of that bad behavior and bring some relief and protection to those who serve the HOA community. And again, that is in effect January 1st, 2025. All right, so that's all I have to say on that one. Back to you, Rob.
Back to me. Well, I hope everybody is enjoying this. And, I read a great quote the other day. It said, "A good lawyer knows the law, but a great lawyer takes the judge to lunch." So I hope you guys all had your lunch and you're enjoying your lunch today. Don't go hungry. Please enjoy our seminar and our webinar as best you can. Some of this can be really dry. We understand that. But we want to make sure that you have the information. And what you're looking at right now on the screen are some pipes and electrical conduit and things that have to do with the duty to repair utilities. This is SB 900. This one is kind of a doozy, and so bear with me on this. It's not one that CAI supported, but it is one that CAI monitored and tried to get amended so that it was a little bit more user-friendly for associations. It's got a sort of a tortured history that I'm actually intimately familiar with, so I'm going to tell you a little bit about that. It started with a problem at a complex up in Orange County, a big condo project, over 200 units, where it was about 50 years old and the gas lines had not been replaced. They were old. There were a lot of pinhole leaks going on that were being repaired on a case-by-case basis. until finally, at one point, there was a big, massive problem, and the lines were shut off by the gas company. And this was a project where the association had control over these gas lines and had the maintenance and repair responsibility. But what happened was the gas company shut it off, and the gas service was interrupted for each of the over 200 units at this complex. Obviously, this caused a great deal of anger and angst in this community. People were not able to boil water, take hot showers. It was a tough time for them. A complete repipe of this development was going to take a long time to occur. But the people were without gas for an extended period of time. They couldn't use their stoves. They couldn't boil water. They were using electrical hot plates to provide hot meals for their families. And it was a problem, not ideal, as you can imagine. So local government actually stepped in. The city council got involved, and Senator Umberg, who was the drafter of this bill, his office got involved as well. All got involved trying to get these gas lines repaired and restored and get service back to these people. They were offering to provide temporary shower services and everything during the time that this project was being administered. But the onus was on the association and the management to get this done. It was a huge undertaking. It was very contentious, a lot of allegations being lobbed back and forth. It resulted in a recall of the board. And it required a special assessment of over $1 million to get this repipe completed at this project. The result of that was that Senator Umberg decided he didn't want to see this happen again. And he drafted this bill, which was intended to address these types of situations. What it says is that what it does is it amends Civil Code Section 4775. And unless otherwise provided in the declaration of a common interest development, so the CC&Rs, or unless the utility system that is failing is required to be maintained, repaired, or replaced by a public or private utility like the gas company or like the water district if we're talking about water lines. This bill makes HOAs responsible to repair and replace gas, heat, water, or electrical services when these services or when systems involving these components are interrupted to the extent that those components originate in the common area. And that's even if these lines extend into the separate areas. It would require the HOA to commence the voting process to start to make these needed repairs and restore service to residents within 14 days. By the way, originally it was 10 days, and they got it extended to 14 magically. However, if a vote is not taken within 14 days, the HOA is still going to be able to obtain financing to commence these repairs without that vote. So what they're trying to do here is trying to make it a little bit easier for associations who have this maintenance responsibility to get these lines replaced and get service back to the people who need it, which is ambitious. And the statute is sort of ambiguous as well in how we interpret it. So go figure, the people in Sacramento drafted an ambiguous bill and it's subject to interpretation. So there are already questions surfacing about how this is going to work and about whether the association has to comply with this for all systems that it maintains or just the ones in the common area. Our interpretation of this law is that if the association's documents clearly delineate the repair obligations for the association and for the individual separate interest owners, then the association is only required to comply with the statute where there's an interruption of service that occurs in the common area. So if the HOA is obligated to maintain, let's say, gas lines like they were up in Orange County, and not the gas company, they need to comply where there's an interruption with this statute and initiate these repairs within 14 days. That's really fast. The folks up in Orange County, it took them a while because the pinhole leaks did not suggest to them that the entire system had to be replaced. The gas company came in and told them it had to be replaced. So you can imagine the mammoth undertaking it was to get people together, to get bids together, to start this process and try to restore gas service when you're working with and against, unfortunately, in some respects, the gas company who has turned off this these services. So if the HOA is obligated to maintain the gas lines and not the gas company, they need to comply where there's an interruption. If the interruption is occurring in the separate area where there's a separate area obligation where the owners have that maintenance responsibility, even if those lines originate in the common areas, there's an argument to say that it is only the separate interest owner that has to take action at that point. It's a little confusing, it's a little ambiguous, but we strongly advise boards regardless that if you don't have a clear determination in your documents about that division of responsibility for these components, consult with your general counsel and let's get those documents amended so that it is perfectly clear what role the association has in repairing these gas, water, and electrical lines if there's an interruption. That is what the takeaway is on this right now. Have a look at your documents, have general counsel take a look, and where it's already clear, the board can defer to those covenants. If not, though, you're probably going to need to have a professional come in and show you where the interruption occurred. And if it's in the common areas, that's where the association needs to step in and take action. So it also amends section 5550 of the Civil Code to require that at least once every 3 years, the association has to get what they're saying is a reasonably competent and diligent visual inspection of the accessible areas where these major components are located as part of the reserve study. So you're going to be working with your reserve study specialist for this particular component of this bill. But that's only if the current replacement value of those major components, so like it's an entire gas line for a 200 unit complex, if it's the replacement value of those components is equal to or greater than half the gross budget of the association, that's when you got to do this part of this. There are requirements provided in that reserve study. You have to identify the major components that have a useful life of less than 30 years. You have to identify the remaining useful life of those components, estimate the cost to repair, replace, or restore those components, and figure out the total annual contribution that is going to be needed to defray the cost. It really is sort of an exercise in reserving. And to have that reserve funding plan in place. Again, all of this is probably going to be done in conjunction with your reserve study professional, and that they're going to really help you out with that. But you can see why they want this to happen. A lot of projects are getting older and older, 50, 60, 70 years old. And if you haven't replaced these major components yet, they want you to take a look at them now. They want to avoid any sort of disaster like this from happening in the future. So one last thing that the bill does is it makes a few tweaks to section 5610's definition of emergency situations. What it does is it expands the definition of an extraordinary expense to include those situations where threats to personal health are discovered and not just simply threats to personal safety. So for purposes of imposing an emergency assessment, it's considered an extraordinary expense necessary to operate, maintain, or repair the common areas where the association has responsibility and where there's a threat to personal health or safety or some other hazardous condition or circumstance on the property. So the takeaway here is to be proactive, ensure your documents are clear with respect to maintenance and repair responsibilities, and so that there's no confusion should something like this happen down the road. Now, with that said, we're going to move on to the next phase of this process. Those are all the bills that we're going to talk about today. There are a few others that came up that were dead that may resurface. There's a gate bill that may become like the SB 326 for exterior security gates. It is not active at this present moment, but we're leaving those on our website so you can kind of see what they look like in case they surface next year. And we'll be back next year probably to talk about that one if it does come out. Now, we're going to move on to case law. And the first case is going to be discussed by Karen again, and it's Morris versus Hayden Estates. Go ahead and take it away, Karen.
Oh, hey, Rob, actually, can you back it up a couple slides? We're
Nope.
gonna, one
Yeah,
more.
this thing is really touchy. Sorry about that.
It's all right.
There's
One
the
more.
one. There's the one we're going to talk about.
There we go. All right.
They're
So
valid.
yeah, we're going to start out with an unpublished case. The Bear Valley case. So if you're a fan of our newsletter, this case was profiled in our March issue, but we thought it was worth going over today again. So in this situation, we have Miss Pina, who purchased a condo and almost immediately started complaining to the board that the roof shingles were worn and really needed to be replaced. It was not up to what she wanted for the roof above her newly purchased condo. So the board's response was not satisfactory to her. So she decided to put a little heat under them and contacted the association's insurance company, called them up. She was not claim for damages. She simply complaining that the board was being negligent, that they were not maintaining the roof, that they were failing in their duties. And what happened next was, instead of getting the result that she wanted, which was a new roof, the insurance company issued a notice of non-renewal, so that now not only did she not have a brand new roof, but she was going to be hit with a huge assessment increase. Her and all of her neighbors were going to be hit with a huge assessment increase to pay for the new insurance policy that increased by 397%. So what does the association do? The association sued her for intentional interference with economic relationship and negligence. So they, at the beginning of the litigation, Miss Pina tries to shut down this litigation by claiming that her communication, her telephone call to the insurance company, is protected speech, that it was in furtherance of her constitutional right to her freedom of speech, and therefore the association cannot pursue their litigation against her. It's referred to as an anti-SLAPP motion. So what did the court say? The court said, nope, your phone call to the insurance company complaining about the board, although, it was about a roof, and, yes, other people are going to be concerned about that too. That was a privately broadcasted communication, right? It was just you picking up the phone, talking to the insurance company. It did not relate to it did not qualify as a public a communication for public interest, and therefore you are not protected. That your phone call, that complaint, what you did is not protected constitutionally, and the association can pursue its litigation against you. So that was what that particular ruling was about. So the takeaway here, members need to be very careful not to interfere with the association's business relationships with insurance companies and other vendors. They can be subject to liability if they do interfere, and it results in damages such as a premium increase of over 300%. All right. But in the same light, we do want to also remind boards that you must be diligent with regard to maintaining the common areas. All right, so Allison, I'm going to throw it over to you for the next case.
Okay. Thank you, Karen. Okay, so don't hate me if I mispronounce this name, but I will give it my best shot. Doox versus ALS Lien Services. So this plaintiff, Teresa Doox, she filed a class action lawsuit against ALS Lien Services. She was a member of a homeowners association up in Danville, California, and her association used ALS for their delinquent assessment collection services. So she became delinquent in her assessments, and ALS sent her a pre-lien letter, which also offered a payment plan for the debt. And she agreed to the payment plan. And in that payment plan, ALS had standard language in their plan that required the waiver of Civil Code Section 5655A. So what does 5655A say? It's a provision of the Davis-Stirling Act that mandates that payments made by a homeowner towards their delinquent assessments must first be applied towards the underlying debt before being applied to collection fees and costs, attorney's fees, late charges, or interest. So plaintiff argued that the waiver that she signed was void as a matter of public policy, citing Civil Code Section 3513, and the court agreed with her. Civil Code 3513 states that anyone can waive the advantage of a law that's intended solely for their own benefit, but a law established for a public benefit cannot be waived by private agreement. So once again, the court agreed with her. The court held that the prioritization of payments, the prioritization requirement found in 5655A, was established for a public benefit to protect homeowners from losing their home due to a small delinquency, and to protect homeowners from abuse by collection firms and overzealous and insensitive associations. So that's a citation from the case. If payments, so the court said if payments aren't going towards the underlying debt first, it creates a never-ending cycle of fees on top of fees that homeowners can't get out from under. The defendants argued that the parties had a private agreement, which should be honored, and that associations are less likely to enter into payment plans without a waiver. The court disagreed with that argument, stating that the public benefit outweighs the parties' right to contract. And the court felt that associations were still going to enter into payment plans, even without the waiver, to recover the principal balance and to avoid the foreclosure process, and to resolve their collection accounts. So although there's multiple, interesting takeaways from this case, the one that we're focusing on is that associations can still have some optional standards in their payment plans, but they cannot waive 5655A as a matter of public policy. And up next, I believe we have Jamie.
Yes, so this next case is actually very similar to the Bear Valley case that Karen just talked about, as far as this theme that's going on with anti-SLAPP motions. So we're going to talk about, and I'm going to be like Allison, I don't know if I'm pronouncing this right. I don't know if it's Dubac or Dubac, I'm not sure, but let's just let's call it Dubac for this presentation versus Itoff. In this case, two owners within a homeowners association, Itoff and Diamond, were sued for making false and defamatory claims and statements about another association member, Dubac, primarily through email. Itoff and Diamond filed an anti-SLAPP motion. Karen kind of described that to you already, so I won't get into that again. But basically, they filed an anti-SLAPP motion saying, our statements are of public interest and therefore they are protected. So Dubac, you don't have a case against us because our emails are a matter of public interest. the dispute between the owners, there's always a backstory, right? Everybody knows when these nasty grams start flying around between owners that there's a backstory. Well, the backstory here is that the dispute started when Itoff and Diamond complained to Dubac that he discriminated against them because they are Jewish and their daughter is African American. So that's where the bad blood started. Some of the statements made by Itoff and Diamond against Dubac included claims, and I'm taking this directly from the case. So here are some of the things that were said in emails. That Dubac was a racist, a narcissist, that Dubac made false police reports against Itoff's family, that Dubac filmed Itoff's and Diamond's daughter on the street from the trunk of his car, and claiming that Itoff and Diamond have a gun. So the list goes on, but I'm sure some of you have heard serious allegations like this before. This is nothing new. All right, so what did the court do with this? Rob, I think you need to change the slide again. It looks like, there you go.
It's really touchy. Sorry about that, guys.
Yeah, no problem. So the court said the statements did not qualify as public discourse, but pertain to private matters between association members. The court's rationale was that the content and context of the statements, primarily conveyed through emails, were focused on personal disputes between the neighbors rather than addressing a broader public concern about the association's governance. So really it's two neighbors, fighting with each other. That's nothing new for all of us, right? The limited identity and number of the speakers involved, confined to the neighbors within a small community. So again, the emails weren't being published to the public. They were kept pretty much private within the HOA and its members. The emails were not disseminated broadly, and they were only directed to really just a select few people. I don't even think in this case that the emails were sent to all the homeowners. I think it was just some of them. The court stated that generally homeowners associations represent the opposite of public entities. They are inherently private organizations, and access to associations typically require a substantial financial investment, excluding the general public. The fundamental purpose of homeowners associations is to exercise control over private property to which the public has no inherent right of access. So, what's the takeaway here? Be really careful about what you write in emails, because the court here said, look, this is not a public interest. Your emails are not protected, and Dubac can go ahead and proceed with the lawsuit against you. So I know our clients over at Davis-Stirling hear this all the time from the attorneys here. Be careful about what you write in emails. It could end up being Exhibit A in front of a judge or a jury. You never know. So just be mindful of that. Okay. And now we're going to go on to Karen. This is a very interesting case.
You know what? Not only is it a really interesting case, but the death knell for this association was an email that was sent among board members. So just to continue this theme, be really careful about what you put in emails, because it will end up in court at some point. So Morris v. West Hayden Estates. This is an opinion from the Ninth Circuit Court of Appeals that came out this summer. This is a rather high-profile case, relatively, so some of you may have heard about it. There is even a documentary that was made a couple years ago about this, and it's rather sensational, so it makes for a good watch. I haven't seen it, but anyway. This case originates in Idaho, not California, but it is Ninth Circuit. And so we are going to talk about it. The plaintiffs, the Morrises, are the owners of the home that you see here on the screen. This is an actual photo of their home. So for quite a while, they hosted a large Christmas event outside their home on their lawn. And then when they moved to a new neighborhood that was governed by an HOA, they wanted to continue this tradition. Now, this holiday event, this Christmas event, took place over about 5 days. At one point, it drew in 1,000 visitors on a single day. But in general, it would draw in, in the hundreds. There were tour buses, there was a choir, there were costumed characters, both Santa Claus, other, holiday characters. There was a hot chocolate station. There was a live camel in the nativity scene. So the neighbors weren't too thrilled, obviously, by the noise, traffic, just in general. So the HOA did discourage the event. But they did not actually prohibit it, but they did discourage it. The board sent a letter to the Morrises expressing concern for this event. That concern, one of their concerns related to the non-Christian residents in the community. They never took any action to actually stop the event, but that statement in the letter and a draft of that letter that was mailed around was really focused on, that was really the a focus of the Ninth Circuit and the jury in the underlying trial. So Morris claimed that in addition to that Morris has claimed that his neighbors were harassing him and his wife over this event because of this Christian practice. So therefore, he sued the homeowner association, claiming religious discrimination under the Federal Fair Housing Act, religious discrimination by the association, and that the association should have done more to stop the harassment by their neighbors. So the Ninth Circuit, this is what they said. In general, it was, oh, Rob, you can go ahead and advance the next slide, actually. So with regard to the neighbor-to-neighbor discriminatory harassment, they found that there just wasn't enough evidence that the HOA could have done more to stop the neighbors' harassment. However, what they did say was, we do not hold that HOAs can never bear responsibility for discriminatory harassment inflicted by one member on another. So they are, they're leaving that door open, saying, hey, just because we didn't find that this particular HOA could have done something to stop the harassment, doesn't mean that other HOAs are off the hook. And you do need to take reasonable steps to do what you can. With regard to the association's discrimination, they did find that there was sufficient evidence, mostly those letters and the draft email, that draft letter that was sent around, talking about the non-Christian, non-religious, atheist type other people in the community. That was enough for the jury to find that the association's conduct interfered with their rights and was motivated by religious animus. So even though it was lots of lights and people and noise and et cetera, there was enough evidence to show that there was discrimination going on. So if you are into this, if this interests you, the oral argument before the Ninth Circuit is actually available on YouTube. The oral argument occurred in 2020 during the height of COVID. So it was done virtually, and it's actually a pretty good watch. So yeah, it's out there, and you can learn more about the court's reasoning and the arguments that were made and all the details. So the takeaway here is it does demonstrate that courts are scrutinizing how HOAs as a housing provider, how they handle the discrimination claims. And they are going to look closely at how an HOA handles those. So although this court didn't find that that the HOA had the authority to do anything, that doesn't take all the other HOAs off the hook. All right, so that's about all I have for this one. Rob, back to you.
Thanks, Karen. We're getting to the end of our time here. It's past the hour. I do have one last case and a little bit to talk to you about with respect to the Corporate Transparency Act. And I mentioned earlier that we had a whole webinar on this topic. It's available on YouTube and on our website. Please check that out for the ugly details of what's required with the Corporate Transparency Act. But a lot of you have probably heard that there was a lawsuit originally after the Corporate Transparency Act reared its ugly head and decided that not only regular old corporations for profit needed to comply with this, but also homeowner associations were involved in the Corporate Transparency Act requirements. There was a lawsuit that was filed in Alabama, and the lawsuit was National Small Business United versus Yellen. Janet Yellen, of course, is the Treasury Secretary. And so she was named in this lawsuit. And the court analyzed whether Congress had the authority to enact the CTA, the Corporate Transparency Act, under various powers that Congress apparently wanted to use for that purpose. The powers over foreign affairs, over national security. They were discussing the Commerce Clause. They were discussing Congress's taxing power. They were discussing the necessary and proper clause, just sort of a veritable bevy of constitutional law topics that I remember from law school back 30 years ago, but maybe most people don't. And so the takeaway here is that there was a lawsuit filed on behalf of this group, National Small Business United, and one plaintiff in particular. And that's a group of corporation agents who is about 56,000 strong. And the court held that none of the constitutional provisions I just talked about justified Congress enacting the CTA. They found it unconstitutional. And the court entered a declaratory judgment that this CTA exceeded its constitutional powers. But what's important about this is that people think that means that it's downright unconstitutional and doesn't apply anymore and nobody has to comply. That's not true. The ruling only benefits the plaintiff members of that particular lawsuit. That's the National Small Business United members, about 56,000 people. And this one guy who has about 2 businesses as part of that organization. So that's what you really need to know about Yellen. The Corporate Transparency Act is still there. There's still a deadline. And if you don't comply by December 31st, 2024, you could be subject to civil penalties of $500 a day, criminal penalties of up to $10,000. We're talking 24 months in prison. It's really just ridiculous, given that it's intended to track suspicious activity, money laundering, terrorist financing. So of course, why wouldn't we include homeowner associations and all of that? It's kind of absurd. So what happened was CAI decided to do something about it. And CAI decided to file their own lawsuit to challenge the constitutionality of the Corporate Transparency Act. A group of members of this organization nationwide got together and filed this lawsuit. There's actually going to be a hearing in a few days on the injunctive portion of this lawsuit. And so we'll know more about it. I don't know that I expect anything to change, however. And so what we're advising everybody out there, especially our clients, but all of you, is that you need to comply with the Corporate Transparency Act requirements. It's going to require that board members and any members who have a 25% or more stake in the community disclose certain information, personal information. The director's birth date, the home address, driver's license numbers, the identity of the person with substantial control over the corporation. That's all going to have to come into play and be complied with. So please take that seriously. Do not just simply anticipate that the lawsuit that CAI filed is going to change anything now. There is a possibility that it could. But our advice strongly to you is to go ahead and comply with the Corporate Transparency Act. Please go to our website and look at our information on the Corporate Transparency Act, the requirements. We do have that webinar available to sort of give you more information on what's required and how to go about complying with that particular law. And again, it's important that this take place so that you avoid the penalties that could be subject to failure to comply. That's really all I had. I wanted to go ahead and throw it back to Miranda for any questions at this point, since we've gone a little bit past our time.
That's all right. There was a lot to cover this year, right? Like curveballs. Thank you to all of our speakers. We'll now move on to the question and answer portion. We have been recording your questions via the Q&A box. If there are any questions we cannot get to today, please look at our next newsletter. If you do not already subscribe to our newsletter, please make sure to check it out, and we will post a link in the chat. All right, so typically in these questions, we pull out a lot of the stuff that can be answered from our website and that doesn't have anything to do with what we're talking about right now. However, this one came up and I deal with a lot of questions from the website, and I feel like it would be really good for everyone if you guys answered this one. Does CA law supersede bylaws and CC&Rs? Is the HOA still accountable to current CA laws and standards? And then they asked if we provide services to update bylaws and CC&Rs.
Did you say when in CA laws? Are you talking about California law?
California, yes. Sorry. Yes.
It depends.
Yeah, the answer is it depends. It really is. It does depend on how the statute is phrased. Obviously, statutory law is going to take precedence, but oftentimes you will see in those laws the verbiage that states unless otherwise indicated in the governing documents. And if that's the case, then your governing documents are going to take precedence over the California law. So it can be confusing sometimes, but you have to kind of look for that language or that verbiage.
And it could say notwithstanding the governing documents, in which case, whatever comes next would supersede what's in the governing documents.
In other words, call your lawyers.
Yeah.
Yes, if there's any question, always call your general counsel and
Yes.
get an opinion from them.
And yes, we handle restatements or rewriting the bylaws and the CC&Rs.
We do. You guys can always reach out to me directly or info@adamstirling.com, and we can get you guys a proposal. All right, so is 2114 the same as SB 326?
I'll take that one because 2114 was my purview. No, it is not the same. 326 was the genesis of the whole balcony bill, and that provides all the changes to the civil code to 5551 that you need to see. All that 2114 did was add civil engineers to the mix. So it doesn't change anything about the balcony bill or its requirements, and keep in mind that the deadline is coming up. All it does is give you the option of using a civil engineer at this point to do that work. And so hopefully there are a lot of civil engineers out there that are prepared to take on that role, and I'm hoping that that's the case. I haven't heard that there are any issues with it yet, but no, this particular bill doesn't change anything else about 326.
It just gave them more people to reach out to help them.
Yeah, and more importantly, it did not extend any deadlines. The deadlines are in place.
Thank you. All right, does AB 2114 include pergolas?
Pergolas.
Thank you.
Figured that's what you're trying to say.
Trying to read it and then trying to say it.
If it's an exterior elevated element that is 6 feet in the air or more, then that's what's included. A pergola, I don't know that that's a structure that people are climbing onto. If it is, then it could be included if it's wood framed. But if by pergola you mean those structures that are sort of in your backyard that are designed just to provide some shelter, no, it's not included.
Is it mandatory to adopt AB 2159?
No, it is not. It's an option for associations to include this option in their election rules. So associations do not have to allow electronic balloting.
All right. Does AB 2460 apply to quorums when voting for revisions of governing documents?
I don't know about that. I'm not sure. I'd have to look at it again.
I don't think so.
I
But-
I don't think so, but I'm not sure. I'm not 100% positive on that.
Okay, so I would tell our readers and attendees, look towards the next newsletter once we get a little bit more understanding of the law.
Yeah.
All right, does electronic balloting apply to changes in the CC&Rs?
Yes, it does. So electronic balloting applies to, you can use it for director elections, I guess recall elections and governing document amendments. The only thing you cannot use it for, you have to use the old paper balloting is regular and special assessments.
Okay.
That's right.
Does the opt-out option have to be repeated each election? Or is it a one-time offer that management has to track?
Our reading of the bill, and remember this is fairly new to us, is that it has to be done before each election. So before each election, you have to give members the option, or you have to give them notice that they, actually, that wasn't the question, was it? It's, do associations have to use the
Do they
opt-out
actually-
method every time?
Yeah, each election, kind of like when you have to put out the notices to the owners about if their address has changed.
Yeah, I would say that's probably something they could do either annually or each election, but most likely annually because information has to be in their annual policy statement.
Yeah.
So I think our position is, though, that it can be done with each election. And if anyone, Rob, Jamie, if you guys have another opinion on that, please let me know. But I think it can be changed if the association wants to change it as they go along.
Yeah, so it'd be in their annual budget package.
Yeah,
included.
I'd agree with that because you're going to have different owners coming in each year, and they need to know whether they can opt in or out. You need to give notice to everybody. And people who previously were using paper ballots now are online and maybe want to do it electronically. So you'd want to do the notice every year.
Thanks, Adrian. If we do not opt out method, we will send the email to all who have provided. However, we do not have some members that have opted out of using their email for notices. Can we assume that they have opted out of electronic voting?
That's a little confusing to answer. So the notice that you give 120 days before the election, if you're using the opt-out method, you have to give individual notice.
Mhm.
So whatever that would be. So if a member has chosen email as their method of individual notice, then that's how they would be receiving this notice. But that's not necessarily the email address they're going to use for the electronic balloting. That still has to be confirmed. So.
I don't think you can assume. I think you have to offer it and let the member respond.
Kind of just like the same thing of like changing addresses.
Right.
And also, if the association does not have an email address for an owner, for whatever reason that they never did or they never responded, they have to send the written ballot. So if there's no email address, a written ballot gets sent.
Yep.
Absolutely.
Okay, can associations use the I stopped because I thought we already answered this, but let me just finish it. Can associations use the annual disclosure as the vehicle to update addresses, update voting preference, update electronic communication preference, or do these things have to be done separately?
I'd say that's also a little complicated to answer. I think some of those things could be done at the same time, but not all of them. So that's just something you're going to have to check with your council and your management company to work on.
Thank you. Only have a couple more. Do associations have to update their bylaws to comply with the member election quorum or just the election rules?
It's good to update the bylaws, but I don't think you have to.
Yeah, I don't think you have to. I think that the election rules are key here, and those are the ones that they're going to be changed for sure. You know, it's always a good idea to review your bylaws, which we will do for you if you need it. I don't know that that's required though.
But also check to see if the quorum requirement is below 20%, right? So some bylaws say the quorum requirement is less than 20%, in which case the statute doesn't apply. Or some bylaws also say there's no quorum at all for election of directors. So if that's the case, the 20% reduced quorum requirement doesn't apply either. So I would say check your bylaws, see what your bylaws say, and then discuss it with the board to figure out if they want to amend, they feel like they need to amend or not.
AB 2460, does this mean board of directors and property management is not allowed to call reconvene meetings without the consensus of the homeowners? How would the association call a reconvened meeting?
Yeah, that's a really good question. And we actually thought about that ourselves, especially if you're going to be using electronic voting. You know, how's that going to work? So I think a lot of this we're going to have to flush out as things progress. But yes, what the code makes clear is what I would envision is something like this. Let's say you have a voting process. Some folks are voting electronically. Some folks are voting with secret ballots still, the mail ballots. You convene at the meeting for the inspector to tabulate the votes. And the inspector at the meeting is going to know if they reach quorum or not, right? The inspector is going to say, okay, we have enough ballots here, we have quorum, we can go ahead and tabulate, or no, we can't, we don't have enough. If there are people actually present at the meeting, it's easy. The membership can actually decide to reconvene at the lower quorum requirement later. But if nobody's there, not enough people are there, I mean, the board will probably really be the ones in a good position to know if they have to reconvene or not. So I think we're going to have to just see how it all unfolds, you know, and I don't know if there's still going to be some folks on Zoom, some people in person, you're going to have electronic ballots, you're going to have mail ballots. We're going to have to wait and see.
So the underlining is seek out legal counsel if you have questions.
Yep, talk to your attorney, talk to the inspectors. I think the inspectors are going to be really important here for the electronic voting. They're going to have a lot of the answers because they're going to have to get their systems set up to comply with the new requirements of the law.
Yeah, Jamie, I'd agree with you. And I think at the meeting, keep in mind that the board members are attending as members, not board members, which
Good
means
point.
they get to vote as members, whether
Yes.
to reconvene the meeting or not. So whoever's chairing the meeting would call for a vote, and whoever's in attendance at the meeting can vote to reconvene or not.
Thanks, Adrian. That's a great point.
Yeah, it is.
All right, everyone. I have one last question that I feel like we really needed to answer. What is the consequence if a board breaks any of the Stirling Code laws?
Well,
Right?
That's
if the board
complicated.
breaks any of the Davis-Stirling laws, is that the question? That's a pretty
Yeah.
broad question.
It is a
Yeah.
great
There are
question.
different penalties for different violations. It could result in any sort of enforcement, civil penalties, litigation, you name it. So again, if there's any question, consult with general counsel or your attorney about what the consequences is of any particular statute or violation that you are faced with. It's sort of a brushing with a broad stroke to say this is going to happen when you violate the Davis-Stirling Act, because any number of different things can happen.
Yeah, the statute itself has in it some penalties. So there are within the Davis-Stirling Act, there's a requirement or an authorization for particular penalties to be levied if there's a violation. And most of the rest of it's just silent. So Rob is right. It would, if there's litigation, then it depends on whatever the outcome of the litigation is.
Perfect. Well, that was actually all of our questions pertaining to the new laws that will be introduced or are already been introduced. Thank you again to all of our attendees and speakers. As always, please do not hesitate to reach out to us with your questions, and we'll see you guys next time.